latest executive actions on immigration have prompted many Americans to worry about the need to prove that they are actually United States citizens. A number of documents can be used to prove one's United States citizenship and depend on the mode in which citizenship was acquired. United States citizens can be divided into two groups: natural born, or those who automatically acquired citizenship the moment they were born, and naturalized, or those who acquired citizenship later in their life, usually through the process of naturalization. Both groups have equal rights and responsibilities, with the sole exception that only natural-born citizens can serve as United States President or Vice President. Natural-born citizens are automatically U.S. citizens by virtue of being born in the United States of America. Birthright citizenship extends to those born in all states, the District of Columbia, as well as the territories of Puerto Rico, the United States Virgin Islands, Guam, and the Northern Mariana Islands. Natives of American Samoa are U.S. nationals, but not U.S. citizens. Natural-born citizens also automatically become U.S. citizens at birth by virtue of having both parents be citizens of the United States. A child in this case can be born outside of the United States of America. At least one of the parents must have been a resident of the U.S. at one point in their life. Natural-born citizens can also automatically acquire U.S. citizenship by virtue of having just one parent who is a citizen of the United States. A child in this case can also be born outside of the United States of America. The U.S. citizen parent must have resided in the United States for at least 5 years, at least 2 of which must have been after that parent's 14th birthday. Naturalized citizens are those who acquire citizenship after birth. This can occur by virtue of adoption by U.S. citizen parents residing in the United States. The adopted child must be under 18 in this case. Or it can occur by virtue of naturalization, which individuals are generally eligible for after 5 years of permanent residence in the United States. Individuals must be physically present in the United States for at least 2.5 years, and absences of over 6 months can result in the reset of the required time frame and even the loss of permanent residence. The time frame is reduced to 3 years of residence and 1.5 years of physical presence in the case of individuals married to U.S. citizens. All individuals applying for naturalization must have been residents of the state or territory in which they are applying for at least 3 months prior to the application, and must remain residents of that jurisdiction until they become citizens. Some individuals, such as those who had honorably served in the U.S. military, may be exempted from the residence and physical presence requirements. Individuals intending to naturalize must file an application for naturalization, or Form N-400, with the U.S. Citizenship and Immigration Services, or USCIS, answering a detailed questionnaire on residence and moral character. Attend an interview during which they must pass the American Civics Test on U.S. history and government, correctly answering at least 6 out of 10 questions. During the interview, the USCIS interviewer may ask other questions to determine that the applicant has met the residence and moral character requirements. Working proficiency in English must also be demonstrated. The requirement is waived for long-term permanent residents over the age of 50. Individuals over 65 may qualify for a simpler test, and those with certain physical and mental disabilities may be fully exempted. Once the USCIS interviewer confirms that the individual has satisfied all requirements, they are invited to take the oath of allegiance, upon which they become naturalized U.S. citizens and receive their certificate of naturalization. Since the mode of acquiring U.S. citizenship can vary, there are a number of documents that can be used as proof that a given individual is a U.S. citizen. U.S. citizens born in the United States can simply use their birth certificate issued by a U.S. city, county, state, territory, or the District of Columbia. Natural citizens born abroad should normally be able to obtain a consular report of birth abroad, or Form FS-240, from the U.S. Department of State, provided their parents registered the birth with the U.S. Embassy or Consulate in the country of birth before the citizen child's 18th birthday. If only one parent is a U.S. citizen, the citizen parent would need to prove at least 5 years of residence in the United States, with 2 of those years being after that parent's 14th birthday. the consular report of birth abroad is prima facie evidence of the United States citizenship. The situation becomes more complicated if the parents never registered the birth abroad with the U.S. Embassy or consulate. In some cases, it is necessary to present a birth certificate issued by the foreign country and showing the names of both parents, accompanied by evidence that at least one of the parents was a U.S. citizen. If only one parent was a U.S. citizen, it would be necessary to prove that the parent resided in the United States for at least 5 years, 2 of which occurred after that parent's 14th birthday. This can be done by presenting the parent's school, employment, or military records, attestations by churches, unions, or other organizations, U.S. Social Security Administration quarterly reports showing the earning of Social Security credits, or affidavits from third parties confirming the residence of the parent in the United States. If the parents were not married at birth, and U.S. citizenship is claimed through the U.S. citizen father, it would be necessary to prove legitimation prior to the child's 16th birthday, with some exceptions increasing that age to 18 or 21. Legitimation means legal confirmation of fatherhood, which varies from country to country. Once enough evidence is collected, a U.S. citizen born abroad without a consular report of birth abroad can apply for a United States passport or passport card by filing Form DS-11 with the U.S. Department of State, or a certificate of citizenship by filing Form N-600 with the USCIS. Individuals who had been adopted by U.S. parents can also apply for a certificate of citizenship as proof of their U.S. citizenship. Naturalized individuals will receive a certificate of naturalization after they take their oath of allegiance. If the certificate of naturalization is lost, a naturalized citizen can apply for replacement by filing Form N-565, Application for Replacement of Naturalization or Citizenship Document, with the USCIS. State-issued driver's licenses and ID cards cannot serve as proof of U.S. citizenship unless they are enhanced driver's licenses or state IDs, currently issued only in the states of Vermont, New York, Michigan, Minnesota, and Washington. Only U.S. citizens are eligible for enhanced driver's licenses and state IDs and must provide proof of such when applying for one. To summarize, the following documents are considered basic proof of U.S. citizenship: a U.S. birth certificate issued by a U.S. city, county, or state, a U.S. consular report of birth abroad, or Form FS-240, issued by the U.S. Department of State, a U.S. certificate of citizenship issued by the USCIS, a U.S. passport or passport card issued by the U.S. Department of State, a U.S. certificate of naturalization issued by the USCIS, which would only apply to naturalized citizens, and a U.S. enhanced driver's license or state ID issued by the states of Vermont, New York, Michigan, Minnesota, or Washington. Logos International is here to assist you with retrieving whatever proof of citizenship you require. We will carefully examine your case to determine which document we should retrieve to serve as evidence of your U.S. citizenship. Please email us at info@apostille.us or call us at 212-233-7061 for a free consultation on your case.